And don't forget that today's hearing was postponed yesterday to 9:30 a.m. exactly. And I know that the Supreme Court will start hearing at 9:30 a.m. exactly. And so we'll go to the Supreme Court at this point.
It's day 3 of the Supreme Court hearing of the election petition of 2020. On day 1, for the benefit of those of you who may not have been able to follow proceedings from day 1. On day 1, when the petitioners came to court, they made an application to the court to allow them to go back and make some amendments to the petition that they had brought to court. The petition had some errors in it, errors that pointed to the fact that the petitioner was demanding that the court grants them permission to rerun the election with the Electoral Commission. That was an obvious error, and they appealed to the court to grant them the opportunity to correct that error. In fact, on day 1, the court did grant them that permission. They went subsequently and effected those amendments to the petition. On day 2, which was just a little over 24 hours ago, when the court convened again, the petitioner once again laid a motion to allow them to pose certain questions to the first respondent, in this case the chairperson of the Electoral Commission. The EC dismissed that application subsequently, giving reasons. Those reasons we will summarize for you shortly, but ahead of today, which the sitting which is about to start in the next 20 minutes or so, that was the announcement made by the president of the panel yesterday, that sitting will start at 9:30. Ahead of that, indications are that the petitioner again will be laying a motion to be granted the opportunity once again to ask the first respondent to provide them, and by them I'm referring to the petitioners, with original collated results from all the constituencies. As to whether this will be granted, we are yet to know. Many of the dignitaries and members of the political parties arriving in a short while ago. We just saw Mr. Gabi Asari-Ochiridako, a leading member of the NPP and a loyalist of the second respondent, President Nana Addo Dankwa Akufo-Addo. He just made his entry to the courtroom. And I have 2 of my colleagues here who will help me to break down the issues to your understanding. Beatrice is here, as well as Barbara. Let me start with you, Barbara. Yesterday, you were here throughout the proceedings, and so I'll just step here and find out from you, so as to break it down to the understanding of our viewers. What exactly transpired in court yesterday?
So in court yesterday, as we put in our commentaries yesterday, the court scheduled yesterday for pre-trial. That is to determine some of the issues raised by the petitioner and the respondent, so we know the way forward for the trial itself. But as was seen yesterday in court, before the court could even raise that, the petitioner, counsel for petitioner, that's Mr. Chachuchi Kata, moved a motion asking the court to grant its ask the ECs some questions in regards to the presidential election that was held in December of 2020. So, I mean, there were arguments on each side, from the petitioner to the respondents, back and forth. And the court rose on the issue. I mean, they were in chambers for close to 45 minutes and came back with a decision that they couldn't allow the motion because it lacked relevance. There was no relation of the issues or the application, there were no relation of, how do I put it there? There was no relation or connection with the issue at stake or the issues filed before the court. So the court said it couldn't grant the motion sought by the petitioner, that is former President Mahama. So basically, that's what happened in court.
All right. Beatrice, let me bring you into the picture also at the moment. So Barbara has told us about the interrogatory application that was presented to the court by the petitioner. But again, within these interrogatories, exactly what was the petitioner asking for? What are the details?
Okay, one, the petitioner wanted to find out from the EC chairperson when she realized there were errors in the declaration. Because after the declaration, there were some, she came back to say there were errors in it, and they came back with different figures. So they wanted to know why, at what point in time she realized there were errors in those, in the results. And then also to find out if they followed previous procedure in the elections, like this last December.
All right, so we've just seen the arrival of some of the members of the legal team of the petitioner. Mr. Abraham Amaliba is one of the spokespersons for the petitioner. He and others have just arrived, and they are making their way into the courtroom right now. Already we've seen the arrival of the chairperson of the EC, the President's representative at the Ministry of Information, Honorable Kojo Oponkroma, has also just arrived and is also making his way into the courtroom right now. But these are beautiful scenes. Yes, the matter is in court, but you see the members of the two opposing sides having a chit-chat right now. Mr. Oponkroma, of course, is one of the spokespersons for the second respondent. Mr. Abraham Amaliba, who is also a lawyer, is one of the spokespersons for the petitioner as well. But they are having a chit-chat at the moment. Soon, the friendly hostilities will start in the courtroom, and this is where you have to stick and stay as we bring you all the details of proceedings as they take place in court today and beyond. But I'm here with my colleagues Barbara and Beatrice as we try to break down the issues as they happened yesterday and what is likely to happen today as well. But Beatrice, so even as we wait for proceedings to start, we also do realize that it appears there's a motion that has been brought to the notice of the court again by the petitioner. Barbara, are we aware of what this contains?
Yes, from what we know, the petitioner is asking for discoveries from the EC. And if you'd allow me, I'll read some of the content.
By all means too, Barbara.
So one, the former president wants the originals of the constituency forms. That's Form 9 for all constituencies in Ghana. The second is that the originals of the constituency's presidential election results summary sheets, Form 10, for all constituencies in Ghana. The former president also wants the originals of the regional presidential results, election results coalition forms, that's Form 11, for all regions in Ghana. And then also the former president wants the EC to provide him or his lawyers the originals of the regional presidential election results summary sheet. That's Form 12 for all regions in Ghana. The fifth is that the former president is asking the EC for the original of the declaration of the presidential results form. That's Form 13. And also, finally, the sixth discovery the former president wants is that the EC provides it with the records of the alleged updates to the purported declaration of presidential results on 9th December 2020 of the results of 4 constituencies in the Greater Accra region. So that's exactly what is in the motion that the court might be looking at this morning, if God wills. Yesterday,
before the court rose, we heard about today going to be used to do case management. Again, we have been told of pre-trial arrangements and so on. What does this motion mean for the plans that were outlined for yesterday?
Oh, what it means is that if the court or the Supreme Court decides to sit or hear this particular motion today, it is going to delay the time for the pre-trial. I don't know how it's going to go. I don't know if the court would want the petitioner to move the motion before the pre-trial, or they want to look at the pre-trial. They want to start the pre-trial before hearing the motion that has been filed by the petitioner.
All right. Beatrice, tell us about the pre-trials so that, again, those of our viewers who are watching us right now who may not know the procedure will get to understand the state in which we are at the moment. What's the pre-trial all about?
Okay. The pre-trial, basically, the petitioner, the parties, let me say the parties, the petitioner and the respondent, they are going to discuss the way forward, how the whole hearing process is going to be like. And then at this stage, they're also going to consider whether to go ahead with it, or at this point whether they think they can resolve issues, and then the petition will not go, or the hearing will not. But then
the chairman of the New Patriotic Party, the party on whose ticket the second respondent, President Nana Addo Dankwa Akufo-Addo, has just arrived. Chairman Freddie Blay is the national chairman of the New Patriotic Party. He has also just arrived, and he is currently making his way into the courtroom. He has been here from day one. Again, for those who may just be paying attention to proceedings, this is day 3 of the proceedings, and we're looking at the election petition 2020. Beatrice, you were telling us about the pre-trial vis-a-vis what is happening here, but the pre-trial, again, what exactly is it? And we will shortly be joined by our colleague as well, Edward Nyakon. Edward Nyakon has just arrived. He will join us briefly. Edward, welcome. We've been talking about events from yesterday, and we've been trying to break it down to the understanding of the many viewers out there who are lay people who do not understand the legal terms, and particularly what actually happened in yesterday in court. You tell us, how did you see the proceedings yourself, or what actually happened? Break it down for the benefit of our many viewers.
Yesterday, what we saw, the petitioner's lawyer, that is in the person of Mr. Chachichikata, trying to do was to seek the court's mandate to enable him to interrogate, as they put it in interrogatories, to interrogate the Electoral Commission. And they posed 12 questions that he wanted to do that, because according to him, he put it this way, in quotes, that he wanted to narrow down the issues so that it can be done expeditiously. But when the court went into their chamber, or to the chamber, when they returned, they realized that they said that it was not relevant to the matters that were at stake, and therefore they have to set it aside. Even though Mr. Chachikata quoted some precedent in the 2012-2013 election petition, according to the court in 2016, they varied some of the rules of the game. And as a result, they will not permit that to happen. So that motion that was filed by the petitioner's lawyer was not upheld by the court. And then we went up, and they were supposed to do case management today, and that is how to proceed. But again, Mr. Chachikata also raised another issue, that they want to go and have a look at the ruling of the court, and then we'll come back today and to let the court know. But when they were leaving, Dr. Dominic Ayene, Mr. Mohammed's, among the legal team, indicated that they're going to study the ruling and possibly, file for review. But today, what we are hearing is that the petitioner's lawyers have filed another motion indicating that they want to see a constituency presidential election results collation form, which normally forms form 9, pink sheets, so that they want to go through it. So that's another issue that has been brought before the court, and hopefully the judges will sit on this matter this morning to determine whether it's in line with the rules of the game or not.
And I've been speaking with Barbara and Beatrice here, trying to project what is likely to happen in court today, because yesterday we told that today was going to be used to focus on case management. We've been told about pre-trial arrangements and so on and so forth. The question is, now that we are picking up signals that there is going to be another motion laid by the petitioner, how will this affect the process leading to the case management, pre-trial arrangements, and so on?
Well, what we can say is that one way or the other, it might, but it depends. This lies in the bosom of the wisdom of the judges sit on the case. It might even affect the 42-day deadline that has been set, because if they're going to go through this process as they did yesterday, that means another day is gone. So probably we have to come tomorrow and look at the substantive case in terms of the case management and move forward. But I believe the judges have experience, because if you look at Justice Anieboa, he was part of the team or the judges that sat on the 2012-2013 election petition. So he has so much experience with regards to these issues. So they know how to go about it, and they will definitely make sure that and they will stick to their time, because there are concerns raised over that a deadline of 42 days. We might not be able to stick to that, and we might lose some more days. But let's not forget that the judges are also concerned about the fact that we are living a time that coronavirus period, where things are not normal. We are new normal times. So they will possibly make sure that the case is dealt with expeditiously. Let's not forget that Mr. Kuntawampao yesterday raised this issue, that if they keep on filing motions here and there, it might affect the issues, because they said that they were prepared to go ahead with the case as it was.
So we'll have to go back to the studio now, where our colleagues Maurice Ogbete, George Sapo, and the rest of the team are having some experts in the studio who will help you to further break down the issues to your understanding. I'll hand over to the studio now. Meanwhile, we'll continue to monitor every little tiny minute detail right here from the Supreme Court, and we'll ensure that we'll bring it to your notice as and when they happen. Back to the studio.
We are live here in the studios. We're also live at the Supreme Court, and as I said, we'll bring you whatever it is that you need to know concerning the 2020 presidential election petition currently being heard at the Supreme Court of Ghana. It does appear that the focus of today's sitting, as we were told yesterday, which is the case management, may be pushed further, either during the day or maybe a day after. We see that how that goes, because the NDC's lawyers are seeking for some discoveries. They want to get some pink sheets from the constituency level, the coalition pink sheets from the constituency level, from the regional level, and for that matter, the national level. We see how this particular motion that they have filed, goes, and how that affects the whole case process. I'm still here in the studio with my colleague George Sapo. We will help you understand the whole process and how it's going. Right.
All right. Thank you very much, Maurice. If you're just joining us, it's our coverage of the 2020 presidential petition, which is coming off at the Supreme Court, and we're starting off right here in the studio. And we went back to the Supreme Court. We're back into the studio to continue with the discussion. When the judges are set and they're seated, we'll take you back to the Supreme Court for the entire hearing. Just as Maurice said, it looks like the case management might delay a bit because of the motion filed by the lawyers of former President John Dramani Mahama. Well, we have our usual guest who's joining us via Zoom, Dr. Kwekwajiman Budu. He's a lawyer, he's a law lecturer, and the head of Law Center, Gimpa Faculty of Law. Our objective, like I always say for this particular program, is for you to understand whatever is happening in the Supreme Court. We understand that not all of us are lawyers, actually, but just to understand the terms, the processes, and what everything really means that's happening in the court. Let's go to Doc. Doc, good morning to you, and thank you very much for joining us this morning.
Good morning, George. How are you doing?
I'm good. I hope you're well.
I'm doing well by God's grace.
All right, and I hope you had a good sleep last night.
Yes, we can't complain.
Okay, all right. Let's start off, for us to understand certain issues, starting off from yesterday. What's case management and what's pre-trial? We can start with the two.
Okay, so usually in litigation or in court proceedings, one of the things that are done before you move on to the actual hearing or the substantive matters in issue is the process which is referred to as case management or the pretrial hearing, as it is sometimes referred to. And usually at stage of proceedings that certain matters are dealt with. For instance, it's usual that during such or during that stage of the process that issues, for instance, the triable issues will be set out and the parties, for instance, will assist court with the issues which they feel are at play for the court to adopt them, to decide upon them once the parties have called their witnesses or due the evidence and things of that sort. So usually and generally, that's what you would expect to see during case management and pre-trials and things of that sort.
Now, and coming out with those issues, are the issues already not in the petition?
So one could argue that by reading the petition that you can deduce essentially from the reliefs that the petitioner is seeking. Will, depending on what infractions or what types of or practice or irregularities that he or she may be contesting, it would inform the type or types of issues that they may want to present for the court for adjudication. So for instance, in 2012, the issues were whether or not there were malpractices, irregularities, and things of that sort, and whether or not, if there were those irregularities, malpractices, etc., those were enough or affected the outcome of the election. And so it depends on the perspective or perspectives of the various parties to the dispute. So for instance, we've seen that the second respondent, I believe, has filed his memorandum of issues, which sets out 3 legal issues, 2 of which they are seeking the leave of the court to argue in preliminary proceedings, preliminary legal arguments on 2 of the issues. The first being whether or not the petition is incompetent and discloses no reasonable course of action in terms of Article 64(1) of the Constitution. Remember, Article 64(1) of the Constitution is the provision that gives people, a citizen of Ghana, the right to bring an election petition before the Supreme Court. And the second issue which they want to argue as a preliminary matter is whether or not the errors in alleged vote padding complained of by the petitioner, granted saying to be true, affects the outcome of the presidential election held on 7 December 2020. And the third issue, which they have filed in the memorandum of issues, is whether or not there is a basis for petitioner's claim that neither petitioner nor second respondent obtained more than 50% of the total number of valid votes cast at the presidential election held on 7 December 2020. So like I'm saying, you can glean from the issues or the memorandum of issues that have been filed by the second respondent that these are the questions that they feel have to be determined for the purposes of dispensing with this particular petition. And we are yet to see the issues that the first respondent and the petitioner royal file. Possibly they have done that already because that was the instruction that was given by the court yesterday. But that will give us a sense of how they are looking at it, because it's possible that their issues may be slightly different, or the focus may not necessarily be similar to that which we have right now. So it's all about perspective, and it depends on what the respective parties feel is important and is at play for the purposes of determining the petition.
All right. So, Doc, we've got signals that sitting has resumed, and so we'll go back to the Supreme Court where the hearing will start this morning.
Electoral Commission. Nana Abdudankwa Akufo-Addo. Please, John Dramani Mahama. Please, your name. Lord Johnson Asiedu Nkatia represents the petitioner. Electoral Commission, our Lord, being represented by Jane Mensah, chairperson. Mr. Mark Manu, our Lord, represents the second respondent.
May it please.
Mr. Sedukatia, please, may you have my attention. May I have your attention? Please, where is your counsel?
Where is your counsel?
At the registry. Yes, please announce yourself.
May it please my lords, Justin Amenuvo appears for the first respondent with me, Somwa Asamoah.
Yes.
If it pleases your lordships, Akoto for the second respondent. My lords, with me are my learned colleagues, Frank Davis, Kweku Esefi, and Yao Opong.
My lords, I apologize for being late. My learned junior is also on his way. We were trying to ensure that we complied with your orders yesterday. We have just succeeded in filing a memorandum of issues. We are also in the process of filing an application for review of your ruling yesterday.
Mr. Chikata.
Yes, my lord.
Yes, we want to have copies and consider it, so we will rise and come back.
Very well.
For the issues.
That is correct.
Yes, okay.
All right.
Well done.
Amen.
of the ruling that the judges gave yesterday concerning the issues raised by the petitioner's lawyers concerning certain questions that they wish to ask the Electoral Commission, of which it was dismissed by the Supreme Court. And after that, when we take you through that ruling, we'll move to our guest who's still joining us via Zoom for us to have an understanding of exactly some of the issues that are actually going. So Maurice will take us through what exactly...
Right, so Judge, this was yesterday's ruling. It says that the petitioner, applicant, has prayed this court to grant the application to serve interrogatories. The basis for the application, as argued by learned counsel for the petitioner applicant, is to assist the court to narrow issues for the trial of this petition. Interrogatories under common law is discretionary. It should be granted or refused when all the circumstances are taken into consideration. It should be noted that the questions seek to elicit answers to the issues raised by the reliefs sought in the petition. Interrogatories must be relevant to the issues and relate to the matters in controversy between the parties, in this case the petitioner and the first respondent. The court is of the opinion that the crucial issue of relevance has not been established in this application. Reference was made to the 2013 election petition titled Nana Addo Dankwa Akufo-Addo and two others versus John Dramani Mahama and two others 2013, in which an application to serve interrogatories was granted by this court. However, the subsequent to 2013, several statutory amendments have been made by CI 99 of 2016, which has restricted the practice and the procedure of this court as regards to election petition. Indeed, Rule 69C4 of the Supreme Court Amendment Rules CI 99 directs the expeditious disposal of the petition and sets timelines for the court to dispose of the petition. It implies that even amendments ought to be sought and granted, as well as joinder of parties. Subsequent statutory amendments pointed out after 2013 have provided us with new procedural regime and strict timelines. We are strictly bound to comply with CI 99 and therefore would not apply Order 22 of CI 47 of 2004 in this circumstance. We accordingly refuse to grant application, and same is accordingly dismissed. And that's from the Supreme Court, signed by all the justices sitting on the case. Justice Yao Apel of the Supreme Court, S.K. Mafo Sao, Justice of the Supreme Court, Nene Amegache, Professor Kote, Mr. Owusu, and G. Tokuno, Mrs. They are all justices of the Supreme Court. And we still have on the line our guest lawyer, Dr. Kuku Ajiman Budu. He will take us through the process. Counsel, are you there? Hello, Doc.
Yes, hello.
Right. So, can you help us understand, in simple terms, this ruling by the Supreme Court yesterday?
I think the ruling is simple enough as you just read it out. It's straight to the point. The petitioner applicant made an application for leave to serve interrogatories, which we explained the other time, on the second respondents, certain specific questions that, in their opinion, would help in the expedited nature that the trial is supposed to take. And the court went on a short recess and came back with this ruling, which talks about the fact that the application did not meet the relevancy requirement and that it was not relevant for the purposes of the determination of the case. And the specific issue of the citing of the previous election petition where interrogatories were allowed, the court essentially distinguished that from now, in the sense that we have a new legal regime in the form of the amendment to the Supreme Court rules that specific timelines for the dispensation of the election petition. And so, for instance, even amendments are not supposed to be granted, but like we said the other time, the court felt that in the interest of justice, it would give the petitioner the opportunity to amend their petition when, technically speaking, it shouldn't have been allowed. So they made that distinction and then dismissed the application as not meeting the threshold for them to be able to grant it.
Right, and so just this morning, the NDC, as we all know now, has filed to review that particular ruling. What does that mean? Is it challenging the ruling?
I mean, when you want a review of a ruling that has been given, you can make that application or request. Whether or not it will be granted is a different issue altogether. We saw the Supreme Court rising to consider, once they have the application before them, to consider the merits of the application for review itself. But one point that we need to point out for people to understand is that according to Rule 71B of CI 16 as amended, even review applications to review the decision of the Supreme Court in an election petition is no longer entertained. So that's for the general petition itself, that there will be no review for that purpose. But as to whether this particular application for the grant of review of the ruling that was given yesterday, whether or not it will be granted, we should wait and see what the Supreme Court comes out with.
So there's a possibility that this one too would be dismissed, because as I said, it is not permitted in the first place.
No, I said the 71B talks generally about the petition itself. That an application, you know, sometimes in certain categories of cases, you can apply for review in terms of the decision if you're dissatisfied with the decision of the Supreme Court, for the Supreme Court itself to review its decision. You will remember that in the 2012 election petition, after the decision was handed out, the then candidate, Nana Akufo-Addo, made a statement telling everyone that he was not going to file for a review of the decision so that the country can move on. It was allowed then, but according to the rules that we have now, review applications of the decision of the Supreme Court in an election petition are no longer entertained. But so there's a distinction. So as to whether the application for the review of the ruling of the court on the matter of the interrogatories yesterday, whether that will be allowed is something that we have to wait to see. We cannot speculate as to how the Supreme Court is going to deal with this particular matter.
All right. Also, this morning, the NDC has filed another motion for discoveries. They want original coalition pink sheets from the constituency, from the regional and the national level. As George said, pointed out, these are matters in the main petition. Why does the NDC want to, get into the matter even before it starts?
Because generally speaking, mutual discovery is generally allowed prior to the trial proper. So it's possible that and discovery, when we talk about discovery, it's a question of or inspecting of documents that may be in the possession or are in the possession of a party to the dispute. And those documents may be relevant for the purposes of dispensing with the matter at hand. So it's possible that both parties may, or many different parties to a dispute may have certain documents in their possession that it will be necessary for the purposes of doing justice and for the purposes of expediting the whole process to make available to the other party for inspection, for instance, so that the matter can be or it can move on smoothly. And so, generally speaking, mutual discovery is permissible, but once again, we saw yesterday that when the motion for interrogatories, which is also another process that is generally allowed in civil proceedings, for instance, we saw that the court did not grant that application, but that is not in any way a suggestion that this may go the same way. We, as I always say, we should avoid speculating as to the specifics or what exactly the Supreme Court may or may not do. We should wait for them to come up with their ruling, and then we'll be in a better position to appreciate, just like how you read the ruling that they gave yesterday, which is now a public document, and we are able to appreciate and understand the reasons why they gave for dismissing that application. So we'll have to wait and see what the court decides in respect to that particular application.
All right, Doug, help us to understand this concerning time and also concerning the 42 days given. I mean, there was a ruling yesterday. There's been an application filed for a review of that ruling this morning, and another one too that was also done this morning. How does that affect the 42 days and also concerning time in this whole case?
I mean, technically, reading the Supreme Court rules, it shouldn't necessarily affect the time frame within which the court has to dispense of this matter, because we know, for instance, that the rules provide that within 21 days after the declaration of the results, a petition must be filed. That's if you're dissatisfied or you want to challenge the validity of the election of the president. That has been done as of 30th December 2020. We also know that subsequently, within 10 days from the date of service of the petition on the respective respondents, that they have to file their answers or respectively to the petition. And once that is done, within 2 days of the filing of those answers, there's pre-trial that's supposed to be conducted, and then the actual hearing takes place and lasts approximately 6 days from the end of the pre-trial hearing, within which, after which, I mean, that the Supreme Court is supposed to determine the matter no later than 15 days after examination of witnesses, etc. So by the 42nd day, according to the rules, by the 42nd day after the filing of the petition, judgment should have been rendered on the election petition as a whole. So generally speaking, from my understanding of the rules or from the reading of the Supreme Court rules, I do not necessarily feel that the time frame. We saw the Chief Justice yesterday in the ruling. I mean, talk about the fact that there's a new legal regime that gives the dispensation of an election petition to be done within a certain specific time frame. So it is the hope and belief that that is what will be done. I mean, I could be wrong, and I mean, it will all be speculation now. We should just wait to see how it plays out. But from the reading of the rules and from the rules itself, it should be dispensed with by the 42nd day.
And still within the rules, that this whole case is supposed to be determined within 42 days, there can't be any presumption of delay, can there?
What do you mean by presumption of delay?
Delay in the sense that someone is deliberately delaying the entire process with the various applications being filed and motions being filed.
I mean, it's so the Supreme Court will deal with these matters as and when they come up and will give the appropriate directions so that the matter is dealt with. For instance, yesterday we saw that after the ruling was given on the interrogatories matter, the court went on to further direct the parties to the petition to make sure that they file their memorandum of issues by this morning, which I believe that the parties may have done by now. I know for a fact that the second respondent has filed his memorandum of issues, but I believe that the other parties have complied with the Supreme Court's direction in that regard as well. So, I mean, it will be up to the court to regulate the procedure, and that's what this whole case management pre-trial is meant for, to set the ground rules, to ensure that everyone is clear in their minds how the hearing is going to take place, the mode of examining witnesses, for instance, and things of that nature, so that the trial is expedited and we're able to get to a decision within the time frame stipulated by the Supreme Court rules, CI 16 amended by CI 74 and subsequently by CI 99.
Now, with these two new applications filed by the petitioners, does it also form part of the pre-trial issues or case management issues?
I mean, there are applications that the petitioner wants the court to consider, which they believe, as yesterday counsel for the petitioner suggested, that far from trying to delay the processes that they are filing are rather going to expedite the hearing of the matter. So it's up to the court to determine whether or not these applications are delaying the process. And that's what, like I said, the whole case management pre-trial is all about, for the court to set the ground rules to ensure that everyone is clear in their mind. So I believe that once the court comes back from recess, we will have a clearer sense of how this whole process will go.
Just on the side, I mean, you're a lawyer, and I'm sure you're also practicing, you're also a lecturer too in law. In handling someone's case, do you consider the procedure in which you would like to handle the case? I'm referring to strategies in which you like to actually adjudicate the case. Do you put all those things into consideration before you go to court?
So as a lawyer, you have certain duties that you owe your profession, you owe your client, you owe the court, and you owe the public generally. So some of the duties that you owe your client include prosecuting their agenda in the best way possible. So the best interest of the client is what is of paramount interest. And so it's not as though, and you take instructions from your client, generally speaking, but it's not up to the client to necessarily determine how to do your job, because you are the professional and you know how to do your job. And so it's not the case that the client will or should tell you how to go about doing your job, even if the client is even a lawyer himself. And so it really depends, but you must understand that you owe a duty to the court itself. So for instance, you do not take frivolous applications or vexatious cases to the court. You owe a duty to the court to ensure that the right processes, that you do the right things, follow the right procedure, and things of that sort, and all that. So there are a number of things that you must consider in dealing with cases generally.
So, I mean, there's a game plan that you have in moving into court. I mean, from what you're saying, as a lawyer, you always have a game plan.
Of course, you need to have your strategy, know how you're going to go about your case, know probably anticipate some of the arguments that the other party may definitely want to bring out or will bring out, so as to be able to counter it. It's like always anticipating what will be done and trying to find answers for those things before they even come up, which prepares you appropriately for the D-Day. So yes, you must, or most often, have the strategy in dealing with cases, but there isn't a one-size-fits-all plan that applies for all cases. There are many different types of cases. For instance, a strategy or process that you will adopt or you would want to use in prosecuting, not prosecuting, in dealing with dispute. Their issues may not necessarily be the same, but it will be up to the court to synthesize these issues or the many different issues that would be raised by the various parties and come out with a definite set of legal issues that the court believes that upon all the issues that have been filed by all the parties to the dispute, that these are the 3, 4, 5 or whatever number of issues that it believes is relevant for the proper dispensation of justice in that particular matter.
Okay, all right. We'll leave it off for here, and we'll get back to you when
and maybe finally before.
Finally, just Morris.
Doc, so after both sides have filed their issues and the court has, as you said, putting them together beautifully, would there be an opportunity for a review if any of the parties feel that their main issues were not captured, by the court?
I didn't hear part of what you said.
And I'm saying that after the two parties have brought up their issues for redress, and the EC has putting these issues from both sides together, would there be an opportunity for a review if any of the two parties feel that maybe one of their major concern was not captured in the process?
I mean, at the end of the day, the courts are there to do justice. So the court, in its own wisdom, is the appropriate not party in the sense of parties to the dispute, but the court is the appropriate authority to determine that these are the issues that will be relevant, the resolution of which will lead to justice being dispensed in that particular case. So whatever issues the court finally decides on, those issues, I believe, will be the relevant legal issues that are in play that need to be resolved for the proper resolution of the matter. So at the end of the day, it will be up to the court to decide which issues amongst all the issues that would be filed by the various parties to the dispute are relevant and go directly to the core of the matter at hand.
All right. Also, in the spirit of time, yesterday we realized that just after the Supreme Court heard the motion by the petitioners, it's adjourned to today. Are we likely to see daily sit-ins so that we're able to finish this case on time? Is it going to be a daily something?
I can't speculate on that. The only thing I can say is the fact that the hearing of the case proper is supposed to last for 6 days. Whether that will be 6 continuous days, we are yet to see. We would have to wait to hear what the Supreme Court has to say in that regard. But I believe that by the time the whole case management pre-trial process is over, we will have a clear understanding of what is actually going to happen and the timelines within which the matter will be dispensed with.
Doc, on a normal day, usual day where there are no applications, during pre-trial and case management issues, how long does it take for that period to be elapsed?
There isn't necessarily any specific time frame with some of these things. It varies, and it will depend generally.
So it can go more than 2 days?
I mean, I don't want to speculate.
We are just speaking in general terms. Sure. I mean, not necessarily to what's happening in the Supreme Court. Just have an idea.
So yes, it depends. It depends on the type of case at hand. Like I said, no two cases are the same, even if it deals with similar issues, because they could border on different aspects of the law. So it depends on the type of claim or the type of claims involved in that particular instance, the court within which the matter is being held, and things of that sort. So it really varies. So it's difficult to give a specific time frame within which some of these things are handled. With commercial disputes, we have the commercial court that is supposed to expedite commercial disputes, for instance. That gives certain timelines within which matters are supposed to be dispensed with. So it really varies from case to case, and the types of jurisdictions that the various courts have in dealing with certain types of cases.
All right, so with the various applications being filed, has it got what it takes to stretch the pre-trial period or the case management period?
Has it got what?
Has it got what it takes? That would it stretch the pre-trial period or the case management period? Would it stretch it with the various applications being filed?
I mean, it's difficult to tell right now because yesterday we saw what happened in court yesterday, and we saw that the court gave the order or the instruction to the various parties that they should file their memorandum of issues today, which was what we were expecting today. But we've seen that today application for review of the ruling has been filed, which the court is studying to be able to come out with a ruling possibly on that particular matter. So it really depends. I can't really speculate on whether or not this is going to drag the process and whether or not it's going to affect the timelines. But we would have to wait and see what the court decides and how. By the time the case management pre-trial is over, we should have a clear sense of the specific timelines and whether or not we're going to meet this 42-day period that has been provided for in the Supreme Court rules. All
right, Doc, just on the side, yesterday after the entire process, on my way home, there's a gentleman in my neighborhood who asked me a question. He wanted to find out why the judges have to actually rise at every presentation made by the lawyers to come out with a determination. So if within a period there have been about 2 or 3, so that means that they'll have to be moving in and out of the courtroom that number of times. He was much concerned about time, much concerned about the patience you need to have to wait. What explanation do you have for such a person?
I mean, it's part of the court processes. Not every single time that they have to rise to go consider certain rulings, but obviously it depends on the nature of the application and whether or not it can be immediately dispensed with, and especially where you have a panel made up of more than or about seven people. It's possible that some members of the panel may have different views and will come up with different rulings, and so there will be a need to synthesize all those things to come up with a ruling of the court as a whole. So it really depends on the application in question, but it is not necessarily a rule per se that every single time they have to go rise. But I mean, the dynamics of the case in question or the application in question will determine some of these things. So patience is really a virtue.
All right, no, we have to leave it here, and thank you very much. We'll get back to you. You're going to be with us throughout the entire period, so we'll get back to you when the judges get back to the Supreme Court and with a determination of what is going to happen afterwards. So we'll get back to you. So we've just been talking to Dr. Kwekwadjiman Budu. Dr. Kwekwadjiman Budu is a lawyer, he's a law lecturer, and the head of Law Center's Gimpa Faculty of Law. He joined us for us to understand exactly what's happening. If you're just joining us, it's the coverage of the 2020 presidential petition, which is being held at the Supreme Court. It's supposed to start at 9:30, which it did start at 9:30. Just when the case started with the various parties and various stakeholders introducing themselves to the panel, the petitioners' lawyers raised 2 issues. First, it's got to do an application to review the ruling of the court yesterday concerning those questions that the NDC wanted to ask the Electoral Commission, of which the judges dismissed those ones. So the NDC wants a review of that particular ruling. The second one is got to do with a motion filed again by the petitioners' lawyers wanting to have pink sheets and from the constituency, regional and national level, and other electoral documents, some bit of called discoveries. And the judges hearing these 2 issues raised by the NDC, the judges said that, well, they'll have to recess and really go back and have a look at the documents, because according to the NDC, they just filed that this morning. That's how come the lawyers were that late in the Supreme Court to introduce themselves. So the judges are currently, as we speak, on recess to determine and look at those issues raised by the NDC. What's going to happen next, we have to wait to know exactly what the judges are going to decide on these issues, Maurice.
Right, so we're still here in studio. We have our men on the ground at the Supreme Court, Abdul Hai Mumen, Edward Nyako and Barbara Kuma, our court correspondent there. They are monitoring proceedings there. Anytime they get any indication or any latest, they will bring you up to speed with that. But just by way of information, these are the justices sitting on the 2020 election petition here. We have Chief Justice Enin Yeboah. He is the Chief Justice of Ghana. We have Justice Yao Appel. We have Mafo Sao. We have Professor Ashikote. We have Mariama Owusu. We have Justice Nene Amegache and Justice Gertrude Tokono. They are the justices sitting on this particular case. We are told that apart from Justice Enin Yeboah, all the other justices are new ones who didn't partake in the 2012 presidential election petition. And also by way of legal representation for the petitioner, who is NDC's John Dramani Mahama, we have Mr. Tony Lita, and led by Mr. Chachu Chikata. They are leading the charge for the petitioner. We have the EC's lawyer, lawyer Justin Amenuvo. He is leading the charge for the EC, together with lawyer A. Asamoah. They will be doing the work for the Electoral Commission. On the side of the MPP, who is the second respondent, we have lawyer Akoto Ampao and lawyer Frank Davis. We have lawyer Kuku Asrifi and lawyer Yao Opon representing the second respondent, who is His Excellency Nana Addo Dankwa Akufo-Addo. This program is live on GTV, is live on Obonu TV, is live on GBC News and all our regional radio stations across the 16 regions of the country. We're still waiting for the court to return from that short recess to tell us whether they are going to hear the motion filed by the NDC for discoveries. They want to have original coalition pink sheets from the constituency level, from the regional level, and from the national level, even before the case itself resumes. Today actually was purposed for pre-trial and, for that matter, case management. That may have to delay a little bit. We'll see how that goes. No matter what happens, we have correspondents at the court, at the Supreme Court, and we'll bring you up to speed with the latest concerning this particular case. You want to stay with us.
All right, so send us a text message or WhatsApp message. The number is on your screen. Let us know what you think, what you make of the coverage so far. Stay with us. We'll be right back.
Sure.
Better family. Kojo B. 2020 the Mahameba. And then we clear cause offer. I go for Dubai and we'll share 4 years, but now so the end will be here. 1 is 3, 1 for 2. Scan the band or your man from me. And penny a band said 2020, but soon near Tim Quim. Abanadi Mahamafa, Namafa, Mahamafa, Namafa, Mahamafa, Namafa. 2020 when you be on pre-cost Mahamafa, Namafa, Mahamafa, Namafa, Abanadi Mahamafa, Namafa. 2020 when you be on pre. Galam say was so be so kina. Oba na okofa soldiers. Wasi intimate na what is scaveters na what is low bed. Ubegunu, tell you betu. Enya bro, ama ya need to. Na pa na pepa na say 2020 ba so near Tim Kwem. Abane de Mahamafa, 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 Mahamafa. 2020 when you be on pre-cost Mahamafa, 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 Mahamafa. Abane de Mahamafa, Mahamafa. 2020 when you be on pre-share. Oba ni obego banks. And then I said the kind of crime tiasi. I will bet my arm and I nice. My mukululu na mashasi. Was ya and Yasun Prilu. What better now so the way any young. Ahoya and you plenty 2020 lesson. Ya mama chance. Mahamafa, 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 Mahamafa. 2020 when you be on pre-cost Mahamafa, 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 Mahamafa. Abanidi Mahamafa, Mahamafa. 2020 when you be on pre-share. Oh my head almost $1 granny. What's this mobile
very well. So GM lawyer Chachu Chikata, no, they have no better particulars. That's why he is playing delay tactics. Abronoma Nyako, Millennium City. I think that's in Kaswa in the central region. The NDC in outside court, you say you have won. NDC in court, you say you want a runoff. Right, that's from a tester from Nungwa. Hi, good morning, sir. I think the judges are trying to protect the image of, that's the opinion. Right, this one says, now that the court has ruled against the petitioner's interrogatories, will there be still avenues for the counsel for the petitioner to ask those pertinent questions they seek to ask Madam Jean Mensah? I think that as time goes on,
you know, if you listen to the first respondent yesterday, right, the first respondent's lawyer yesterday, well, he stated that these questions that the petitioner has actually raised are in the petition itself, and they have responded to it. Sure. Of which Mr. Chikata said that, well, they've agreed. Since he said they've responded to it, that means that there's an agreement that, I mean, these questions are that relevant. So I'm sure when the time gets there, they will raise this.
And also don't forget that they are seeking a review of that ruling yesterday. Yeah. So we wait to see what the court says, whether they are going to uphold that review and allow them to go ahead and and ask her those 12 questions. This one says, hi, I'm watching from Glife in Dansoman last stop. It will be very difficult for JM to okay, all right. So this one says, hi. All right. So the COVID-19 is real and no respecter of persons, rich or poor. Wear your nose mask to protect yourself and others, but let Mr. Mahama and the NDC know there is no time to waste on their petition, which is, you describe it as frivolous and vexatious election petition, as described by the second respondent. I think that, I mean, it is very imperative that we wear our nose masks. I think some 3 days ago, Ghana recorded the new variant of the COVID-19 disease at the airport. And so this is a point where we have to take our own destinies into our own hands. Wear your nose masks, wash your hands, sanitize them if you have a sanitizer. The integrity of our judicial system is under serious scrutiny. The judges should remember that one day they won't be there again. So their integrity and the national interest should be protected, not the precedents that will ruin our democracy. Ghana must rise again, you added there. All right, so this one says Ghana will win. Hi, I'm watching from, okay, I think I've read that one already. This one says, good morning. Our judges should know that the destiny of Ghana is in their hands, so they should be careful. Good morning. All right, the same message Then let me read some few more messages. We'll try and see if we can get Abduhai Mumen and the team at the Supreme Court, and then they will bring us, what's happening around that particular area. Interesting in Ghana here, election petition. John Mahama should just accept defeat like Nanado in 2013. However, I may say that the NDC are wasting their time. Abubakar Salam, you guys are too much. Keep the good work going. Thank you very much, Abubakar Salam. There. This one says, interesting in Ghana here, election petition should just accept. Okay. All right. Okay, so good afternoon. I am watching live from the Upper East region. Please, I would like to know if 1 + 1 is equal to 2 is correct. Why then should 1 + 1 is equal to 3 affect the results, which is 2? Your message is not too clear there. We're still receiving loads of messages from our viewers.
The interesting thing about the various comments coming in, this is live on television. It's also live on the internet and almost every social media platform. So people actually are watching, and they are forming their own opinion and thoughts as to whatever is happening in there. So I'm not surprised about the various comments coming in from our viewers and also those listening to us too on radio.
Right, and so and let's say these are their opinions.
Yes, these are their opinions.
Not our opinions.
We just have to engage them to let them know exactly what you also make of the entire process.
Sure. Yeah. All right. So we are watching keenly. The court must do the right thing by allowing the EC to ask such important questions. Peter from Bacho now. Good morning. My name is Francis Enim. I believe in God and the NDC. Maybe you wanted to add.
All right.
Why can't the NDC wait until question time? Why can't the NDC wait until question time or cross-examination time?
Right.
And they ask the EC all these questions. This from IK Nungwa, and he says that he feels it's some way of delayed tactics from the NDC.
We'll take you over to join Abduhai Mumin. We'll be finding out some thoughts from him. He is at the Supreme Court, and we're going to get in touch with him shortly. But I think we're not being fair to those listening to us on radio. The number actually on radio, if you want to send us a text message or WhatsApp message for those listening to us on radio, 055-744-6429. 055-744-6429. 055-744-6429. That's for those listening to us on radio. But if you're watching television, the numbers on your screen, you can get in touch with us and send us what you think and some of your thoughts. We'll read it out. Yes,
right. So George, whilst we wait to connect with Abdu and the team at the Supreme Court, let's read some some more messages. This one says, good morning, I am Samuel Owusu Echampong, currently monitoring proceedings from Doha, Qatar, glued to my TV set. Thank you very much for watching far away from Qatar, Doha. You have to stay glued to GTV because we will bring you the reports as, you know, we gather them from the Supreme Court. Good morning. In fact, I like the lawyer for the first respondent, and that's the EC's lawyer.
Yeah.
Is it Justin Amenuvo? Right. So this one says, thanks for reading my message. Thank you very much for reading my message. This one says, the substantive matter for interrogatories was unanimously quashed, but it seems the NDC's joy lies in the mention of Jane Mensah instead of the EC chair. Ghana politics is sweet. Ghana is sweet. Adrianaba from Abeka Republic. Yeah. This one says, delay tactics pioneer from Buedu Emmanuel Ahafo, Mem in the Ahafo region. Hello, you guys are doing a good job. Keep it up. Ghana wins. Certainly, Ghana is going to be the winner after all is said and done. This one says, Ghana shall rise again. My name is Blah. NDC lawyers are indeed good, but they are delaying the process. They are delaying the process.
But that's just like what Dr. Kwekwaji Mambudu said. And if you read the documents or the procedures that the Supreme Court has actually given out for the hearing of this particular petition. Everything is supposed to be heard within 42 days. And that's the expectation. So let's just wait and see exactly what's going to happen on the 42nd day, which will be the final day of this entire process. So let's wait and see. Unlike the 2012-2013 petition that went into 8 months, but this one, there's been a limit to it. So like the 2012-2013, the NDC even joined in that petition, but for this there's been that limit, so it's just the 3 of them, so nobody else can actually join in the entire process. So and the court has also given 42 days, so let's just wait and see exactly what will be happening within this 42 day.
All right, so hi, my name is Gilbert. I want to ask whether Asiedun Ketia is at the Supreme Court, because he said, okay, right, so I think today Asiedun Ketia he's actually representing
John Dramani Mahama,
the petitioner, who is John Dramani Mahama. Good morning. Good morning. The NDC is winning the case on point. I am Rina Ray GH from Kaswa. That's your opinion. It's the judges that will determine who wins this particular case. But in the end, it is Ghana that wins. The courts may grant the petitioner's request to interrogate the first respondent. I am Frank Mensah in Accra. Hi, good morning. I'm Samuel Boafo, and I want to congratulate you on the good work you are doing. I think this petition is not needed because everything shows clear that the MPP is the winner. Thank you very much for acknowledging our effort. This one says, why can't the EC be allowed to answer the questions? Courage is my name. You didn't add where you are testing from. Good morning. To you guys, I think the judges are not being fair to the NDC, but God being on our side, the NDC will be victorious. That's your opinion. Tell McMail, hey. All right, that's fine. Okay, so this one says, hi GBC, talking point. My name is Sydney Abaka from Canada. My interest in the case is to see how Jen Mensah will feel and respond to Tony Lita and Chikata in the box. That's your interest. We are very much allowed to have interest. Good morning. Michael Owusu from Asokwa. NDC should accept their defeat and the MPP should be happy for their victory. Thank you guys. Okay, so this one says that my name is Papaya, watching from South London, UK. Keep your good work. So we have a viewer, you know, way far in South London watching us. We thank you for staying glued to GTV, for that matter, GBC News or Bonu TV, any of the channels you may be watching at this particular point. Felix from Teshi, the Supreme Court has a big task ahead because it's quite obvious Mr. Chikata wants to make their work easy, but they themselves want to delay the process. And so, George, I hear we have to go back to the Supreme Court. The judges are back to deliver that ruling on the motion that the NDC filed early this morning.
All right. So let's go over to the Supreme Court. I'm sure we'll interact first with Abdul Haim and then we'll move into the chamber itself.
All right. Many thanks to you, Morris, and our colleagues in the studio, George as well. Well, the judges are yet to return to the courtroom after they went into chambers to consider the motion that was applied for by Mr. Chachuchikata, who is the lead counsel for the petitioner, President John Dramani Mahama, former President John Dramani Mahama. And I'm sure that you are aware that as soon as proceedings began today, the counsel for the petitioner indicated that he wanted a review of the decision that was taken yesterday in respect of the application for interrogatories, which was dismissed by the court. Before then, we had also cited another motion which the petitioners
intended to lay before the court today that we haven't heard of yet, but it has to do with asking the chairperson of the EC to make available collation forms, the forms that have become known as the pink sheets, that these pink sheets be made available to the petitioner throughout the process of this case. My colleague Edward Nyakon joins me to bring you an analysis of what has happened so far. So, Edward, we didn't get up to 10 minutes of sitting this morning before the jury went into chambers. For many people, the court even hadn't sat yet. What happened?
Yes, it's because of the motion or the appeal that is being made by the lead counsel of ex-President John Mahama and the President Mr. Chatrichi Carter, who is asking the court to look into their own decision that they took yesterday as to the question. They said that it was not relevant to the issue at stake. So he's asking them to look into it again, and it's normal, it's within the purview of his rights to do that. So he's come to court to say, look, yes, I agree with the decision you took yesterday, but still I'm not okay with it. Let's look into the matter again. And that's the beauty of law. So that has caused the judges to go retreat and to go and look at the matter, because they need to come out with the various legal backings to buttress the argument they put forward yesterday. So they will certainly go in there to look at it, and perhaps, like I said, the second motion have been filed. Might have also, because Mr. Chatrichi Carter need to also present his argument before that decision will be taken into that one will also be taken into consideration. So that is what has necessitated the ladder we experience, or the break that we experience now at the moment.
One of the main arguments advanced by Mr. Chatrichi Carter counsel for the petitioner yesterday had to do with the fact that there is a precedent, and so he referred to the 2012 election petition which happened in 2013 and actually quoted judgments by Justice Gbadegbe himself, which sought to support the fact that this had happened already in the past. Some interrogatory applications had been admitted, and therefore, following that precedence, he believed that his application should also be granted. He has a point, doesn't he?
Yes, as for court legal issues, you always have a point, but it's also the judges who sit on the case and have the right to also come out with their verdict. And so if you look at what they said yesterday as part of their ruling, they cited that 2016 there's been some amendment, because 2012, 2013 was a novelty that the path that we took. So it was a move by the court to say that, okay, yes, it was, but remember there's been some changes along the line. And let's not also forget that we have set ourselves a deadline of 42 days to finish this matter. So yes, you quoted some ruling, but we've moved ahead of that. We've also amended ABCD, and that's how we can grant you your request. And so we'll go back to we're saying that, look here, it cannot be granted. Let's tackle the substantive matter, and that's what they proposed, that let's look at the case management and the way forward, which Mr. Chatrichi Carter requested. They want to have a look at the ruling, and then they will come back today. And just as Dr. Ayeni said yesterday, they will definitely appeal or go for a review, and they've done that today.
So what this means is that the plans were told about yesterday, just before close of day yesterday, we were told that today would be used for case management, pre-trial arrangements, and so and all of that. This means that might not happen today.
Still, I will say that the judges have the right to decide whether they're going to, because they can come back and say, look here, we've looked through your matter, your review, and this is A, B, C, D. They will come out with their verdict. And secondly, in reference to the second motion he has applied, yes, whether they will allow for argument to be made today, it lies in their bosom, and so they have the right to do that. But once I believe that they have set themselves a deadline, I'm certain that they will go by, because yesterday, let's not forget that the Chief Justice said that they want to be a bit flexible. though they have a deadline, they want to be flexible. That is how some legal pundits are also saying that perhaps they will not be able to stick to the deadline. But that's the beauty of law. Let's see how it goes, because at the end of the day, it is the judges who have the ultimate power to decide what is within the remit of the law and what is not within the remit of the law.
Many of our followers, viewers, especially on social media, have been sending in their comments. Some seek to suggest that these peripheral issues, so to speak, might end up delaying the entire process. But I also recall that even in 2013, there were several instances where the substantive matter was put aside and other peripheral matters discarded with before we continued with the substantive issues. And so you will recall that in the early stages of the election 2012 petition, there was the amicus curiae, Benoni Amekuji, who came in to, as a friend of the court to make some applications. His applications were heard, but later dismissed, of course. We also do know about the several cases of contempt that were heard during the 2012 election petition. And so this is not new at all, that certain matters other than the substantive matters have to be dealt with by the court. Edward.
Exactly, because if you're a lawyer pursuing a case, I think that you know what you want to achieve. So you have your game plan. So it's just like a coach. So you have your plan A, plan B. So who knows? This might be part of the game plans to get exactly what they are looking out for. So like Mr. Patricia Carter said yesterday, this is aimed at narrowing down the issues and to elicit some response from the EC. So these are some of the things they put out there to get the specifics they are looking for. Nobody knows what is in his mind. He knows what he's looking out for. And therefore, we don't have to discount on these things. It is part of a legal issue that needs to be brought up. And so it's up to the opponent also to raise issues, because at the end of the day, you need to quote specific laws to buttress your argument. And that's exactly what is happening. And I always say that, look here, that is what democracy is about. I say what I want to say based on the law, and then we chart a new course. And on her side, you will realize that the judges that are sitting on this case might have experience, not all of them sat on the case, but they might have a look at what transpired in 2012. So yes, we countenance what happened in 2012, but perhaps this time around, we've got some experience under our sleeves. We're not going to consider all these peripherals, like using your word. And so we're going to go forward and deal with the substantive matter. But like Chief Justice said yesterday, they want to be flexible and then let the case pursue. That's how you threw it to the various, the petitioner and the two respondents. They should come together and agree on when to start the case management, and there wasn't a consensus.
Again, let's talk about what happened in court, albeit very briefly. We realized that on day one, former President John Dramani Mahama himself was in court. On day two, which was yesterday, he was in court himself. Today, we haven't seen him physically. We've seen Madam Jane Mensah together with her deputies in court today. Okay, so now we are getting signals that the judges are returning to the courtroom. We will continue to bring you details. Edward, you would have to move in there. Thank you very much. We'll hand you back over to the courtroom. The analysis will continue from here. We'll bring you all the details. Stay with us here on GBC platforms.
Anyway, I saw it too. All right.
by court. We have considered the petition and the answers to say by the respondents and the memoranda of issues set down by the parties. We accordingly set down the following issues for the determination of this petition. 1. Whether or not the petition discloses any reasonable course of action. 2. Whether or not, based on the data contained in the declaration of the first respondent and the second respondent as president-elect, no candidate obtained more than 50% of their valid votes cast as required by Article 63, Clause 3 of the 1992 Constitution. 3. Whether or not the second respondent still met the Article 63, Clause 3 of the 1992 Constitution threshold by the exclusion or inclusion of the Techiman-South constituency presidential election results. 4. Whether or not the declaration by the first respondent dated the 9th of December 2020 of the result of the presidential election conducted on the 7th December 2020 was in violation of Article 63, Clause 3 of the 1992 Constitution. 5. Whether or not the alleged vote pardon and other errors complained of by the petitioner affected the outcome of the presidential election results of 2020. By virtue of the powers vested in this court under Rule 5, Sub-Rule 4 of CR 99 to dispose of this petition within strict timelines, the following orders are made accordingly. 1. Mode of trial. The petitioner and the witnesses shall file witness statements with exhibits, if any, by noon of Thursday, the 21st of January 2021. 2. The witness statements shall be served on the counsel for the respondents by the close of the day of Thursday, the 21st of January 2021. 3. The respondents and their witnesses, if any, shall file their witness statements with exhibits, if any, by the close of the day on 22nd January 2021. 4. The first and second respondents shall file their submissions on the preliminary objections raised to the petition by 12 noon on Friday, the 22nd of January 2021. 4b. The registrar shall ensure service of the submissions of the preliminary objections by the close of the day on Friday, the 22nd of January 2021. C. The petitioner shall file any response to the submission of the preliminary objection by noon on Monday, the 25th of January 2021. D. The registrar shall ensure service of the petitioner's response by the close of the day on Monday, the 25th of January 2021. E. Ruling on the preliminary objection will be incorporated in the judgment of the court. Timelines. The court shall sit on Tuesday, the 26th of January 2021 for hearing of this petition.
My lords, we have just heard the orders that you have made. We thought that part of the hearing this morning was in effect to enable us to make representations on the various things, but it looks like your lordships have made certain orders, and there is some degree of unclarity, at least in our minds, as regards what is referred to as a preliminary objection. Because, my lords, there are, in the two answers, there are a number of different things that are referred to. I'm actually not clear.
Of the preliminary objection. The issue to be determined as preliminary objection. That has been set out as read by the President of the court.
Well, perhaps we could hear it again, because it was not...
is whether or not the petition discloses any reasonable course of action. That's it. Yeah, please, we will instruct the registrar to type the orders by the close of the day, and they will be served on you. because it's case management. You have to be fully informed of the orders.
My Lord, with respect, it is case management, and I believe we have an input that we can also make as parties, because we had, for instance, witness statements. Is it by tomorrow? I mean, my Lord, with the greatest respect, I mean, we are human. I mean, maybe they're superhumans, you know, but we have filed this morning, as of this morning, we have filed an application for review of a ruling that you delivered yesterday. There are consequences to that. We also have outstanding requests to admit facts, which are due within 3 days from when they were served on the other party. There are a number of outstanding issues which have not been discussed.
Mr. Jigata, there's no outstanding issue. The application for review of our ruling yesterday does not operate as a stay of execution.
Well, I did not, with respect,
we are operating on strict timelines under CI 99.
And you have the notice to admit.
Yes, but my Lord, it can affect the issues. In fact, your Lordships will recall that yesterday, when we were discussing the filing of the issues, we raised the point that the matter of the interrogatories and the notice to admit facts could affect the issues that we filed. There are some issues that we may not actually require.
Mr. Chikata, if you get there, can't you apply for these issues to be taken as an additional issues?
Yes, but in the meantime, we'd have filed witness statements, yes, which are limited to.
You are call 5 witnesses. I believe you should know what they are coming to say. As at the time you were indicating that you were going to call 5 witnesses.
Yes, so we are going to have 1 day within which to supply witness statements in respect of 5 witnesses. Is that? I think that I think that with respect is not fair to us, because with the greatest respect, we have indicated that we have 5 witnesses. We may end up not calling all 5 witnesses, but in any case, we have now, today, until tomorrow, in order to prepare witness statements.
Mr. Jikata, this should have been prepared already. No. Well, these statements should have been prepared already.
Well, that is not correct. maybe in your Lordships, maybe your...
Mr. Jikata, excuse me. Mr. Yene, please resume your seat, sir. Please, you are a senior member of the court. When the bench engages counsel, you don't sit down and make gestures as if you are part of the legal team. I've been watching you. Please, this is not fair. You see, the other time we heard you clear when an objection was taken, when the representations were announced. I even asked Mr. Chikata whether they were limiting themselves to the only 2 counsel. Mr. Chikata, I think you remember the very day, and you said you were with only Mr. Luther, and you were recorded as such. But Mr. Ayine, please, out of respect for you, please don't do that again.
Mr. Chikata, if you recall, we've gone through the regimes of CI 87, we've gone through the regimes of even witness statements in criminal matters, and so where we've arrived at now in administration of justice and case management is preparing everything up front, and I'm sure you are quite aware of that.
I'm aware also of the fact that it is a matter which parties may make representations about. That is a matter of whether it is conducted through witness statements or through oral testimony. I mean, that is also a matter to be considered on the basis of representations made. But, I mean, your Lordships have made the orders already, and we will be served with them, and I believe we will advise ourselves. But I do feel obliged to indicate that the timeline that is provided for us to have witness statements, does not seem to be justified.
But Mr. Chikata, you know about CI 99 and its schedule. That's the 2016 law.
I do know about the schedule provided, but I also know that your lordships are here to administer justice, and that justice must not be sacrificed for expedition.
The petition is hereby adjourned to Tuesday, the 26th of January 2021 for hearing.
You are grateful to the court.
Please resume your seat, please.
My lords, we are most grateful.
All rise.
came out of court. You all know what was scheduled for today was to be the pre-trial hearing. But before that, the petitioner's team, lawyers, had indicated that they had filed an application for a review of the court's ruling yesterday on the dismissal of the interrogatories. Well, the court took cognizance of that and retired into chambers to consider the issues that we had been ordered to all file. So at the end of the day, the court came back and read the memoranda of issues. 5 issues have been set down for the trial and determination of this petition. I'm confident that in the short course of time, you'll be apprised with the issues that have been set down. The court has also given an elaborate timetable for the hearing of the petition in strict conformity with the CI 99. So we are all supposed to be back on the 26th of January, that is Tuesday, this coming Tuesday, for the hearing of the petition to commence in earnest. It is instructive to let you all know that the 3 issues that we set down as our memorandum of issues have been incorporated largely in the issues set down by the court. Now, the court has also set down for legal arguments, a preliminary legal argument, whether or not the petition discloses any reasonable course of action. Indeed, in second respondent's answer, that matter was raised by the second respondent's legal team as a matter which should be considered by the Supreme Court, and that has been set down for preliminary legal argument. When the decision and the rulings of the court was read, lead counsel for the petitioner raised the matter as to the filing of the application for review. But that was sharply responded to by Professor Ashi Kote, Justice of the Supreme Court. We all know as lawyers that the filing of an application for review does not operate as a stay of proceedings of the matter in court. Well, the return date for that application is tomorrow, the 15th. It's tomorrow. We will be in court tomorrow for that application to be heard. So yes, that is what transpired in court this morning. I don't understand what that submission is supposed to mean. They always are the first to make those submissions, but that submission has no place in law. As petitioners, they should have known that CI 99 governs these proceedings. And CI 99 has been in place since 2016. When did they realize about expedition, delay, and justice? Of course, expedition is justice. You don't come to court with a set of rules and you want to circumvent and obviate the rules by your own careless abandon. How do you come to court with a petition and you don't know that you have to file a witness statement? You don't know that you have to settle a memorandum of issues? I don't understand what is meant by sacrificing justice on the altar of expedition. Justice delayed is justice denied. So what is it? They are just not ready. It should tell all of you. They were advocating for a live broadcast of the proceedings. Not averse to it. Everybody is seeing what is happening in the Supreme Court. Every single day, lead counsel for the petitioner has one complaint on the other. You cannot blame the failure of a bad farm on your tools of implementation. Your farm is your farm, and it depends on how you cultivate it. So we should also not pander to this repeated rhetoric of sacrificing justice for expedition. It is the main reason that the election petition of 2013 delayed for 8 grueling months in court. Are they anticipating the same thing? I believe not.
That the call for a review of the court's decision is not a stay on proceedings. However, as an interested party, are you not concerned that in the future, when this case has traveled and the issues are brought back, that it could take all of us back to the very beginning of matters?
The Supreme Court is the determinant of its own rules. There are set rules governing the election petition. The application for review will be heard tomorrow. Whether they are successful or not is not left to me. I'm a trained lawyer, I'm not a clairvoyant. So what happens today will determine the course of the proceedings. Final question? Any more? Thank you. Thank you.
Please. It's okay. It's not working. It's okay.
Okay. All right. Good morning.
All right, Counsel, thank you very much. Give us your reaction to the court's ruling today.
Well, we are quite shocked because we are here for pre-trial, for case management, and for those who've been in court, we know what case management is. Case management is a discussion between the parties and the court as to how the trial is going to proceed. Today, that's not what happened. We were told what is going to happen. There was no discussion as to what our views were on how the case should proceed. So we are quite shocked.
We understand tomorrow is the day you will come and argue your case out.
No, that's not the case. What the court said was that we file our witness statements by tomorrow, by 12 tomorrow. Now, that means we have just one day to prepare the witness statements. Now, you are all aware already that we had an application for interrogatories. We've served them with notice to admit facts. We've served them with notice to actually inspect documents. All those things have not been attended to. We have actually filed an application for review of their order yesterday relating to their refusal to grant us leave to serve the interrogatories. That has actually been fixed for the 28th. Now, all those things will have an impact on the kind of witness statement we will prepare and file. So if those issues have not been dealt with, those applications have not been dealt with, how do we file witness statements by close of business on the 21st? For us, it's shocking. It really doesn't make sense to us as lawyers who've been practicing in the courts for so many years. And we know what the rules are. We know what the rules are.
Counsel for the second respondent saying that you're not well prepared for this trial. You seem to raise objection to everything the court raises.
And every objection that we've raised is grounded in law and is justified. I'm sure you are all witness to the arguments made by lead counsel yesterday. Did those arguments sound like they were just a ploy to delay the case? They were grounded in law. The fact that the petitioner has interrogatories to serve on the respondents. Now, interrogatories, as he stated, are to aid the trial of the case. And indeed, if a petitioner who has, or an applicant who has good grounds for serving interrogatories is denied the opportunity, for us that's a denial of justice.
In terms of the timelines that have been imposed, I mean, as it stands now, that is the timelines you all have to work with. I mean, is it something that you will be able to meet? And in terms of your case, you are the ones who have brought the petition to court. What does it mean for putting together a solid case to put across your points?
Now, let no one say we are not prepared. If we're not prepared, we wouldn't have come to court, we wouldn't have filed the petition in the first place. All we are saying is that processes we have served, processes we have filed, processes that need to be dealt with have not been dealt with. How do we start a trial? That is all we are saying. So if you ask us to come to court on the 25th to commence a trial, How are we going to start a trial when our notice to admit facts has not been dealt with? Our interrogatories, our application for review of interrogatories has been pushed to a date after the trial has started. I mean, it doesn't really make sense to us. Unfortunately, we have to say this.
Given your experience at the bar and with the experience of the 2013 petition,
yes,
and the position you are now in, do you think that the 42-day timeline is realistic enough for you to conduct an election petition?
Please note that under the rules, the schedule, there's 5 days for pre-trial. Today is the second day.
Exactly. So what's the rush for?
So what is the rush? Today is the second day for pre-trial.
5 issues have been set down for trial. What do you make?
Well, we are yet to, I mean,
serve the order.
We are yet to be served the order. We are now going to look at, because it was just read to us. We need to now sit down and look at it. Did it? Because we have also filed our memorandum of issues. Does it take care of all the issues we put before the court? Because that would have been the essence of case management. The parties going back and forth on the various issues they filed and the court bringing it together so that we are all agreed on the issues. That didn't happen. So we are now going to look at it to see whether it addresses the issues that we have raised in our memorandum.
Your colleague, Dr. Ayemi, was remanded by the court for certain gestures.
Doc, you do that.
Doc apologized, and I think that should end it. He's a gentleman. I don't think he'll ever be deliberately rude to the court. The court took offense. He apologized, and that ends the matter. So thank you very much.
Can we get two versions?
Yes. Baba Jamal.
Yes. Yeah. This one, you are dealing with your friend.
Yes.
Your friend.
The tree can come up.
Mr. Ene, once my boss I have a specific question. Which
What has accounted for the inability of the plaintiff?
No, it is not the inability of the petitioner to bring witnesses. All right, we had indicated, in our petition that we will be calling most likely 5 witnesses.
Yeah.
Okay. Now we thought that at case management, at the time of case management, which is 5 days of, okay, a 5-day timeline granted by the court itself in the new rules. Okay, we thought that we should be in a position, okay, to plan together with the other parties on how many witnesses we are going to call. So it was not the case that we are not prepared with our witnesses. It is just the case that we are met with a situation where we are being given 1 day to prepare our witnesses and then make sure that we file the witness statements, by noon of tomorrow. So it is not about, it is about tight that are being given by, and I think that the court is being very unfortunate. When you have indicated that pursuant to CI 99, there are 5 days for case management, and all of a sudden the case management is reduced to 1 day by the court arbitrarily without any consultation with the parties, all right, then that is our lead counsel Tachuchikata made it very clear. They are seeking to sacrifice justice on the altar of a so-called speedy trial. Okay, and that is not fair. The fact that we spent 8 months, right, dealing with the first presidential petition does not mean that now everything we do must be geared towards, attaining a speedy trial at the expense of fairness. Okay, and I think that is a very worrying development.
But your opponents also say that justice delayed is justice denied. Speed
and justice probably go together in this instance. And the assertion is that you are delaying.
No, that means that you cannot sacrifice one for the other. Justice delayed is justice denied. That is true. However, the court itself has indicated that we have 42 days to complete this trial. It means that in the wisdom of the drafters of the rules, that is the Rules of Court Committee, 42 days are sufficient for purposes of conducting a trial in relation to a presidential election petition. Okay? You cannot now begin to truncate and deny the parties the right to be able to, for instance, file preliminary, applications that are mandated and allowed by law just because you want a speedy trial. Okay, and I mean, to be honest with you, I was shocked at what was happening, and you all realize that the Chief Justice singled me out, that my body language was inappropriate. But that is because I was very shocked, because after 25 years of law practice, I have never seen this happen, that a court will arbitrarily announce the timelines for the parties without consultation. I had occasion to ask Mr. Akoto Ampao why he did not object to the tight deadlines. Okay? And sitting down there, it reminded me of an inscription that was on the desk of my secondary school rector in Notre Dame Secondary School. It said, "Don't confuse me with the facts. My mind is made up." Thank you very much, ladies and gentlemen.
Thank you very much. Honorable Kojo Ponkroma, who is the President's representative at the Information Ministry, will speak to us now. Yes, so how do you react to everything that has happened in court today, very briefly, sir?
I think all of us need to go back to the basics. Ordinarily, when you file your petition and the respondents file their answer, the next logical step is case management, which starts with a setting out of the issues and then a timetable which includes when witness statements are filed. On the first day when we came, our colleagues from the other side started off with an interlocutory application asking for leave to go and amend. And therefore, they started delaying the 42-day clock. That was granted. We had the opportunity to come back earlier this week, and the afternoon before we appeared in court, they filed another interlocutory application, which, as you all saw, took us, almost 2 hours or so, and the court dismissed and said, let's go back to case management, which is what we should be doing now. Every lawyer knows that by now, when you are coming to court for case management, first, your memorandum of issues, you've drafted it. Second, your witness statement, you have a draft of it. So these matters become procedural. Because our colleagues are seeking to delay the process and get a media spectacle ongoing for some months, all they are doing is theatrics in the chamber, seeking to delay the time. So today, even after the court has ruled, or just before the court rules, they bring another application for review. Every lawyer knows that the law is that an application for review or an appeal does not operate as a stay of proceedings. Every lawyer knows this. So you cannot claim or pretend before the cameras that by mere virtue of the fact that you have filed an application for review, there ought to be a stay of proceedings. Because it has actually been, I think, slated for hearing tomorrow. The return date, I think, is tomorrow on it. It will be heard.
Counsel for the petitioners feel that they in fact took an exception to the argument that they are delaying the trial.
They are allowed to take an exception.
What they are doing is due process.
They are allowed to take an exception. But I want to come to another issue. When the court determined in the end that witness statements should be filed on X or Y date, you can check from any other lawyer. Mr. Mahama filed his petition on the 30th of December. True or false? Okay. Nobody chose witnesses for him. He listed 5 people that he had as witnesses. That presupposes that he knows who they are. He knows what they are going to say as witnesses on his behalf. Today, when the court says that by this date, bring me the witness statement, now they say it's too short and that they are being rushed into putting together witness statements. We didn't choose their witnesses for them. From 30th of December till now is what, 20 or 21 days? And Mr. Mahama's lawyers are saying to us that they have not drafted witness statements. They don't have a draft of it. From 30th of December, when they filed their petition and chose their own 5 witnesses, they didn't know what the witnesses were going to say. They haven't drafted it. Respondents have listed what they want to do, and we have a fair idea what it takes to contend this case. Now, if they claim that they need to go back to the interrogatories before they can agree to the issues as have been set out and prepare their witness statements, what it means is that their application for interrogatories were a fishing expedition. That what they were doing was to use it to explore what issues they can come to court with. They have been very clear to the Ghanaian public that Mr. Mahama won this election. Mr. Mahama himself at his press conference said he won the presidential election. That means what? He got 50% plus 1. You have an opportunity in court to prove that. Now Mr. Mahama abandons that one and moves on to this new thing of nobody got 50%. And when we say bring your witness statements, he says it's too early to bring his witness statements. Okay. That's ridiculous. And we are of the view that these are just efforts to delay what CI 99 sets out clearly, that there must be justice, but it must be done expeditiously. Nobody is short-circuiting the process.
You seek to emphasize the fact that your opponents are seeking to delay the process. Because what do they stand to benefit if they delay the process?
For a media spectacle so that Mr. Mahama can continue to remain very relevant in the NDC and in the public space and run again in 2024. That's all they are looking for.
He stated that in terms of case management, it should be done among the parties involved in the case. But this time, the court has set its own rule, and they find it very ridiculous.
That is not true. You were all in court yesterday. In fact, even yesterday, when the court said that they should make their input into the first part of case management, which was the memorandum of issues, you saw them object. The court could have set, in fact, traditionally, the court will set out the issues. Now with the reviews, CI 87, etc., with the reviews, the court will invite counsel that give us your memorandum of issues and let us come up with a timetable. Let's listen to your issues and simplify. We went with 3 issues. And then the court came up with about 5 issues. 2 other issues that we were not contemplating. The court has added it as the list of issues. We are not complaining. We think we can respond to
right. Honorable,
this claim. You were all in court yesterday when they were even asked to file their memorandum of issues. You noticed that this morning they were late in the chamber. They were late in the chamber because they claimed they were now filing their memorandum of issues after they submitted their petition on the 30th of December. Now they are being asked to bring their witness statements. They are suggesting that it's too early. 21 days after they told the whole world that these are our witnesses, they have evidence to support our petition. And that is why we are saying that they are continuously trying to put impediments in the way because they want a media spectacle.
Honorable, for the millions of Ghanaians, lay persons watching us right now, who perhaps also sympathize with your side and who do not understand what the court ruling was today, how would you summarize it to them?
The court has ruled today that let us get on with the issues. Let the petitioner prove that nobody got 50% plus 1. Let the petitioner prove that the results were in contravention of Article 63 of the Constitution, as he's been claiming. I would have even preferred that they had come back to say that Mr. Mahama won this election. But you notice that they have abandoned that since they came to court. And so the court did not pick that as an issue. But what the court has said is that all the gymnastics around, let's get to the substantive issue, and has asked us to come and deal with the issues that it has said. In Chi,
all right, thank you very much. And that was the Minister for Information, Mr. Kojo Ponkroma, speaking to us earlier. We also spoke with the Minister, the former Deputy Minister and Attorney General, Dr. Dominic Ayine, and both of them telling us their points of view as to what happened in court today. The Minister for, the President's representative at the Ministry of Information, making a claim, a very strong claim, and I'll be joined by my colleague Edward Nyakon, Barbara, who also joined me at the moment. So as we begin to wrap up for the day's events, Barbara, let me start with you. The minister says, well, now the court has given, paved the way for the proceedings to hear the substantive matter to begin. What was your understanding of whatever happened in court today?
Well, I think I'm going to agree with the minister when he said that, I mean, the court says that now let's stop with all the gymnastics around. Let's get into the real matter. Let the petitioner come and prove his case. Come and prove to the court if he indeed has any case to be argued about, or to even for the court to listen to. So yes, I think it's about time we started the trial itself, and the court has said it, that next week, Tuesday, 26, we sit on the petition itself.
Edward, but again, we notice, I mean, proceedings came to a halt for the jury to take a break and go into chambers to take a decision. But that was because the lawyers for the petitioner had asked for a review of the decision that was taken yesterday, dismissing their interrogatory application. Again, when the court came back, one of the issues they spoke to was the fact that, well, the fact that the petitioner has asked for a review does not place a stay on the proceedings, and therefore the proceedings will continue. But then again, the question is, at what point will a decision be taken on the review? And if a decision is taken and it goes to the advantage of the petitioners, will that not then put everything in reverse gear, since we would have moved forward at a point?
Well, if you listen to the arguments put forward by both sides of the coin, that is the second respondent legal team, as well as the petitioner's legal team, you realize that if you look at it from the view of the second respondent, they are claiming that it does not affect the substantive matter, because the judges are masters of their rule. And so if they are set tomorrow for that, and they are expected to also to file their memorandum of issues and witness statement today by close of day, it doesn't change the matter at stake. And so they are in a position to deal with it. And but if you look at it from the angle of the petitioners, they are also saying that, look, it will affect the statement of the memorandum of issues and witness statement they will put out there. So these are all legal issues, but let's not also forget that the court indicated that they have looked at, they should all be mindful of CR 99, which sets the rules that, look here, we're not going to go the way we went 2018. We have to set a rule, and there has been a review, an amendment to all those previous issues. So pre-trial matters should not be able to stay or prevent this substantive matter from coming on board. So this is how the issues are playing out.
I'll come back to you, Edward, but the issue, and let's toss this around amongst us. You know, the lead counsel for the petitioner says it appears as though the court is sacrificing justice for expedition, justice for speed. Does he have a point? I mean, from the arguments he made and so on. You have been reporting from court for a long time. Is there a way that justice goes with speed at the same time?
Yes, definitely. I mean, it is not every time that you come to court and the processes are delayed here and then and all that. I believe the Supreme Court and the justices of the Supreme Court are well aware of the laws, and they know exactly what they are doing by asking that we fast track the process. At the end of the day, justice will be done to whoever deserves justice. And so, well, the petitioner, they have their own issue, but I believe that the law is working, and that is what we should allow, or we should allow to go through the whole.
All right, Edward, your take on that as well?
Yes, it goes back to the CR 99 that judges refer to, that Mr. Chikata should refer to the CR 99, which he agreed that he's aware of that, the schedule that indicate that it must be dealt with within 42 days. So in the purview of the judges, this is the way to go. And as always said, they are the masters of their own game, because they set the rule and they can do whatever they want to do with the law.
We have to go now, but very finally, so court sets again exactly when? Because we heard announcements about filings being done on Thursday and on Friday. Yet
the substantive matter court sits on Tuesday, but on the review, it will be done tomorrow.
So tomorrow we are coming back to court?
Not for the substantive matter, but for the review. But for the filing of the witness statements and other processes, it should be done within by the close of this week. That is what the court has ordered.
All right. Thank you very much, Barbara Kuma, and thank you also, Edward Nyakon, my two colleagues who have been here with me in court. Earlier, we also spoke to our other colleague, Beatrice. Yvonne, our other colleague from the radio, has also been here. We will continue to bring you all the details about election petition 2020 and whatever you need to know, including what will happen tomorrow. This is where to get all the authentic information. My name is Abdulhai Mumin. We are grateful that you have been doing this with us. We'll go back to our studio where our colleagues are standing by to bring you further analysis of all that has happened in court today.